Welcome back, focused learners. Okay, let's dive right into today's explainer, which is serving as your ultimate exam recap on the tricky, sometimes overlapping nuances of statutory interpretation. If you're prepping for an exam on statutory drafting, you already know that general rules are rarely absolute. The real test of your legal knowledge, and honestly, what examiners absolutely love to grill you on, is how well you understand the carve-outs. So today, we're going to decode the structural anatomy of exceptions, provisos, and saving clauses, giving you the exact pointers you need to tackle any hypothetical scenario with absolute confidence.
Here's the exam prep blueprint we're following today. We'll be hitting 1. Defining statutory exceptions. 2. When exceptions swallow rules. 3. Purposive construction in action. 4. Exceptions versus provisos. And 5. Quick exam recap pointers.
Section 1. Defining statutory exceptions. Let's start with the foundational building block of our entire revision session. The crucial point you need to grasp here is that an exception is a highly intentional carve-out from a general rule. It's a deliberate legislative decision to exclude a specific category from the operation of the main enacting clause. It's basically the legislature saying, hey, this rule applies to everyone, except for this specific group or situation right here. For your exams, highlight that word in your mind, deliberate. It's an active exclusion, taking a subject completely outside the purview of the main rule.
Section 2. When exceptions swallow rules. Now, this definition naturally leads us into a massive inherent tension in statutory drafting, and it's a delicate balancing act. What happens if courts stretch an exception too far, if they interpret it with, say, undue elasticity? Well, the fascinating logical danger is that it might just swallow the entire rule itself. The general rule requires strict entry for exceptions, because if you let too many cases slip through, the main rule becomes entirely toothless.
And the real-world stakes of that logical danger are brilliantly illustrated right here in the 1998 Supreme Court case of Director of Education versus Pushpendra Kumar. This case perfectly demonstrates why judges sometimes have to strictly rein in lower courts, purely to protect the integrity of a main statute.
Let's walk through how this builds step by step. So, in Uttar Pradesh, the general rule was that government vacancies had to be filled through prescribed procedures, giving eligible folks the chance to compete publicly and transparently. Makes sense, right? But there was a 1974 rule creating an exception. If a government employee dies in harness and the family is left in distress, one dependent could actually get an appointment without going through that ordinary recruitment process. Here's where the tension hits. The High Court took a super broad, elastic view of this compassionate appointment provision. They essentially said, well, if a dependent is qualified for a higher level Class 3 post, the government should just create a supernumerary or extra Class 3 post to give them the job. But the Supreme Court had to step in and strike that down. They held that you can only give a Class 3 appointment if a vacancy actually already exists. If it doesn't, you can only offer a lower Class 4 non-teaching supernumerary post. Why? Because forcing the creation of higher-level posts would completely undermine and swallow the ordinary recruitment rule. The High Court tried to expand the exception to protect the beneficiary, sure, but the Supreme Court strictly limited it to protect the rule itself. Keep that specific phrase in your back pocket for your essays, protecting the rule.
Section 3. Purposive construction in action. Okay, but courts aren't always strictly limiting exceptions. Sometimes they have to fill gaps interstitially based on the actual purpose of the law. Let's look at the flip side of the coin with the 2010 Nizamud versus Chemplast Sanmar ruling. We have Coastal Regulation Zone, or CRZ rules, which strictly prohibited the handling and transfer of hazardous substances. The substance in question here was vinyl chloride monomer, or VCM, a really crucial raw material for making PVC. Now, the rules had an exception permitting transfers from ships to ports, terminals, and refineries in port areas. The proposed arrangement was to move the VCM from the ship to the marine port and then via an underground pipeline to the PVC plant. But a strict, literal reading of in-port areas would mean you could only move it around inside the port itself, completely blocking the pipeline from transporting it onward to the industrial facility. It would have made the exception practically useless. So, applying purposive construction, the Supreme Court read in-port areas as in or through port areas, making the whole thing workable. The judges didn't overreach, but they filled the gaps interstitially to advance the remedy.
Section 4. Exceptions versus provisos.
Moving on to what is arguably the highest yield part of your exam prep, understanding the boundaries between these neighboring legal concepts. If you mix these up on an exam, it's going to cost you points. Grounding this in a really relatable, highly testable hypothetical, imagine a basic rule that just says no vehicles inside the park.
An exception would be written like, except emergency vehicles. The rule is no vehicles, but emergency vehicles are taken completely outside its operation. It removes that specific case entirely. A proviso, on the other hand, modifies the rule. It would read, provided that vehicles may enter for maintenance purposes between 6 a.m. and 10 a.m. See the difference? A proviso doesn't carve a whole category completely out of the rules universe. Rather, it introduces a condition precedent. It says the main rule still applies, but we're qualifying it under these very specific circumstances.
Seriously, take a mental screenshot of this matrix right now. Mapping out the juristic function, the nature of rights, and the specific rules for pleading in court is your ultimate blueprint for acing those essays. Let's walk through it. First up, the juristic function. An exception restrains the purview to specific cases. It creates a clean departure. A proviso qualifies the purview, acting as a condition precedent. And a saving clause? That's entirely different. It simply preserves the status quo ante from the effects of a repeal. Second, consider the nature of rights. An exception limits existing rights. A proviso can limit or qualify them. A saving clause is strictly preservative. Third, and this is absolutely massive for any procedural questions you get, the repugnancy rules. In court, the plaintiff must negate an exception in their initial claim. But for a proviso, the burden shifts entirely. The defendant must actively plead the proviso as a specific defense. Finally, the effect. With an exception, the rule simply doesn't apply to that particular aspect. With a proviso, it remains dependent on the main enactment. It's constructed in relation to the main rule, and you can't just completely detach it.
Section 5. Quick exam recap pointers.
Okay, let's consolidate everything we've covered into some rapid-fire takeaways for your revision. When you sit down with your exam paper, these are the core principles you need to instantly recall. These 5 pointers are your golden keys. 1. Exceptions demand strict entry. If interpreted with undue elasticity, they swallow the rule, just like we saw with the compassionate appointments before the Supreme Court stopped them. 2. Judges cannot overreach, but they do have the power to fill gaps interstitially. 3. Purposive construction allows an exception to be expanded slightly, like reading in as in or through, if it's strictly necessary to advance a remedy and make the statute workable. 4. An exception removes a case entirely, while a proviso modifies a rule with a condition. And 5, that procedural goldmine we just talked about, plaintiffs must negate exceptions in their claims, while defendants must actively plead provisos as their defense.
I'm going to leave you with this final, pretty provocative thought directly from the source notes. Legislative drafting isn't always perfect, right? Sometimes lawmakers use the word provided when they actually mean to create an exception, or vice versa. This is called linguistic corruption. But as a student of the law, your job is to look past the superficial text. When you face a really tricky statutory question on your exam, are you going to let technical labels fool you, or will you uncover the true substance and purpose of the law to find the right answer? Keep seeking that deeper understanding, and best of luck with your revision.